This subject fee agreement was illegal, against public policy, and clearly excessive. And if you look at the case law surrounding this hybrid agreement,
Let me ask you a factual question to help me understand the fee agreement. There's language, and I know there's, I guess, maybe a finding by the trial court, or at least an argument that it was modified later. But as written, it talks about a $5,000 a month that would be applied to expenses and towards fees. And then it says the aggregate amount will be credited to you upon any recovery made by this firm on your behalf in excess of $5 million, provided the contingent fees are paid. Do I understand that language correctly to say if the firm recovered more than $5 million, her hourly fees would be credited to her? If they recovered less than $5 million, her hourly fees would not be credited to her?
that is correct.
And then the modification that, I don't know if I should use the word allegedly, or did the trial court find that it actually occurred?
The trial court found that it occurred and enforced it.
Okay, so the modification would have essentially taken out the less than $5 million, there is no credit.
Correct.
Okay, go ahead, I'm sorry.
No worries. If you look at the cases surrounded this hybrid agreement, all of them have the same structure. The attorney takes a reduced rate on the front end, whether that is like a reduced retainer or a reduced hourly rate, and then on the back end they receive a contingency fee. And that did not happen here. This attorney charged a full hourly rate of $500, which he testified was his absolute premium rate, which even both experts at trial said they were excessive for the Jacksonville community. And then on the back end charged 25% contingency. What this amounts to is double dipping. He got double paid for his work.
Do you think he got double paid just because of the way things happened to work out in this particular circumstance? Because it seems like doing 10 hours of work a month when you're talking about 5 different legal jurisdictions and, you know, trying to coordinating with local counsel and whatnot, that could amount much more to $5,000. The expectation would be this is going to be cost more than $5,000, 10 hours a month.
Well, and I think we have to look past the $5,000 a month, because it wasn't, I will do work for you just for $5,000 a month. He was billing her hourly. And I think that's where the analysis has to go. Eventually, she would have paid for everything, that was essentially like a payment term, whereas he was still billing her for the full hourly rate the entire time. And so I think that's really where, again, the analysis has to go. He was charging her a full hourly rate. And so regardless of how much he would have spent, he got fully paid on the front end.
So just to make sure I understand that point, if there had been no recovery, and assuming it's a recovery, from the trust, even though she was only paying $5,000 a month, the rest that was charged hourly would have been due and payable at the end of the representation?
Yeah, absolutely it would have. Because that is kind of what they agreed to in that agreement. It was the per hourly rate. And there's authority within Florida that essentially an attorney cannot collect twice for the same work. The 50 CA in the Mangle case has several footnotes that kind of talk about this. And that case it's a fee shifting case against an opposing party, so they weren't addressing the actual validity of that agreement, but they actually called doubt as to that agreement. And I think it's footnote 2, they talk about how it's doubtful whether they would even enforce it. And so, again, here we have this attorney collecting twice for his work.
Is the analysis different under the agreement as the trial court found it to be modified?
So I think, well, let me back up. I think this agreement is void even with the modification. And the reason why is the full front end hourly rate. Again, that does not qualify as a hybrid agreement under the language in Lane versus Head. That talks about it has to be a reduced rate where the attorney would receive less than the customary rate, and then on the back end an opportunity for an enhanced rate. And so I think even kind of regardless, but that oral modification I think was done essentially to try to save this agreement. It was asserted 2 years into the litigation, and there was
2 years into the litigation over entitlement and amount of fees?
Mm-hmm. 2 years into the litigation, that was asserted. And the estate had an affirmative defense that basically said, let me find it. It was illegal because they didn't credit the hourly rates paid, and that's on page 33 to 44 in the record. So again, this oral modification did not come about until 2 years later. And that was, the amendment was actually over the objection of the estate, basically saying this did not happen this way.
So the client was already dead at that point?
Correct. And because she's dead, she can't testify from the grave that this didn't happen. The only testimony on this alleged oral modification was the attorney's own self-serving testimony on the issue. It's not memorialized anywhere. It's not documented. He just says this is what we agreed to because she panicked.
Okay, hold on. Let me make sure I understand. So, it probably should be obvious. The oral modification occurred when the client was alive.
Correct.
But there was already litigation about fees, or no?
No. So
Okay.
kind of the timeline was the representation, the trust got dissolved. He makes a demand while she's still living for like approximately $700,000. And then approximately like a month or two later, she's dead. And then he makes a claim to her estate for those funds, and then litigation proceeds. So during the entire course of the litigation, she had been deceased.
So the claim that he made was based on the agreement as unmodified.
Correct.
And then it came to light during the litigation, we actually modified the agreement, so I'm not double dipping. I'm only going to recover the hourly rate, or I'm only going to cover the percentage and give her credit for the hourly rate.
Correct. Now, and I know opposing counsel has basically argued that if you look at the amounts claimed and what was filed in the probate, that, he did, this is evidence of the modification, but if you do the math, the numbers don't add up. The numbers that he filed in the probate were $672,000 and then a $6,200. And that amounts to like $35,000. This is why I'm a lawyer and I don't do math, but it's about $35,000. So it doesn't quite add up to actually what was paid from the client, which was $64,000. And so we don't believe that that's actual evidence of that this agreement was modified.
Well, counsel, if we just assume that there was a modification and that was a valid modification assumption, would that solve this problem? Would the hybrid fee structure be okay if they had the modification as the appellees say it happened?
I still don't think so, and I think the problem is that full hourly rate on the front end. And again, just going back to the language that the Florida Supreme Court had in Lane.
So the fact that there was a full hourly rate makes it invalid, even if they later say we're going to credit that entire amount if there's a contingency?
Yes.
Doesn't that really meet the purpose of having a hybrid agreement?
Well, the purpose of having the hybrid agreement is to, again, it's that reduced rate on the front end, so the attorney knows going in, there's a chance that they're going to get paid less. And then if they're successful, they can make more on the back end, and that's the entire purpose. It's basically to allow people who necessarily, maybe not on cases that's full contingency, like personal injury, but cases where they can't afford to pay that full fee, that there's an opportunity.
So we have a rule of law that if an attorney is charging a full hourly rate, there can be that any hybrid fee structure is per se invalid as violative of what a hybrid fee structure is supposed to be. In other words, you must have a reduced fee,
Right.
or it's completely invalid. And what do we have to support that?
And again, just going back to the language in these cases that talks about a hybrid fee agreement has to be a reduced rate. Lane versus Head, Arabia talked about it as well, that it was, a $10,000 retainer. This court in Gray, again, talked about it, how it was the full rate of $350 and then the contingency. And this court found that it wasn't a hybrid agreement because it was a full rate. And so I think if you look at kind of these things, that is where it is. And there's some cases where there was the crediting issue going on. The Goodman case they credited, but again, if you look at it, it was a $1,500 flat fee amount, and I believe the fees in there were very hefty, and so again, I think you have to look back at what is being charged on the front end, whether or not it's a valid hybrid agreement, and it is our position that this oral modification is invalid, and the reason why is it's not in writing. The bar rules require contingency fee agreements to be in writing, and there are several federal cases, which I know are not binding on this court, but I think are very persuasive, that did not allow for this modification, and that's Foodtown, Bantaprops, Harborough, and again, none of those enforce any alleged oral modifications. And it's also our position, too, that even if this court finds this agreement valid, that it should still reverse. And that's because there was no recovery to trigger the contingency, and there was no claim that would, again, trigger the contingency. This agreement said, you agree that in the event of any affirmative recovery on your claims, we shall be entitled to 25% of your claims. There was no dispute, there was no demand, there was no litigation. The trustee, Mr. Hubbard, unilaterally terminated the trust to avoid the new tax law.
Wasn't there evidence that he said he wouldn't have done it had she not had this representation and her affairs in order, so to speak?
Not exactly. And I think if you read the actual testimony, he said that I was happy that she had professional financial management, professional tax advice, not that Mr. Rubin was representing her. And so I think that it's a fine line in the testimony, but I think that's where it leans, is he was happy that she was getting some type of financial assistance.
Let me ask you one more question. There's a sentence in the agreement I might not be understanding, but it says, any payments, transfers, or recoveries of assets in excess of the $15,000 a month that she was receiving shall constitute an affirmative recovery on your claims for purposes of this agreement. That sounds like what happened, that the dissolution of the trust constituted a recovery for the purposes of this agreement.
Well, we disagree with that. And the reason why is because it talks about, you're receiving these trusts, and it assumes that thinking about this, it almost assumes that she wasn't entitled to that money, but she was legally entitled to that money. It was hers. And again, if it's...
Well, isn't that true for, say they found up in Canada a trust that was set up by the parents for her benefit, she just never knew about it, or the trustee was secreting it from her. I mean, she's always entitled to the money that they prove that she's entitled to. I mean, so how's that any different?
Well, I think the difference is these trusts were known. He didn't have to go investigate. He didn't have to do anything. They knew about these. She was getting $15,000 a month from these very trusts. So he didn't do anything to investigate, whereas in any accounts found in Canada, he would have had to gone out, investigated, found those accounts, made a claim for them. And again, boils down to no claim was ever made for these trusts. The trustee unilaterally terminated them. And I think that's really, kind of what it boils down to. And I say I have 1 minute left, so I'm going to reserve that for rebuttal.
Thank you, Counsel.
Good morning. May it please the court, Courtney Brewer on behalf of the appellee. There is nothing in Florida law that prohibited Ms. McMahon from entering into this agreement with Mr. Rubin. The rules recognize and authorize partial contingent or hybrid agreements, and the comments to the rules also talk about how clients can provide success or bonus fees to their counsel, and that these types of alternative arrangements are effective for structuring fees. The basis for the calculation just has to be clearly stated. It can't be subject to unilateral exercise by the attorney, and the fee has to be reasonable.
All right, let me ask you to do some math for me then.
Okay.
the award in the judgment here was $643,500. How was that what does that consist of?
So the 25% is $708,000, and the trial judge subtracted all of the fees, all of the hourly fees and expenses that Mr. Rubin had charged to Ms. McMahon, which was, I think,
64, somewhere in that
$64,000.
range.
What?
Why wasn't that the subtracting the 64 at a minimum? Why wasn't that error in light of Mr. Tanner's testimony that a reasonable hourly fee in these circumstances would have only been in the $50,000 range?
Well, if that was an error, then the error would be in our favor, and so only $50,000. I think that the trial court determined that the hourly fee was not clearly excessive when set at $500, and decided to credit all of the hourly fees, and so I think that helped him get to the point where this is going to be a benefit to the estate anyways. And speaking to the $64,000 and why when the claim was made on the estate it wasn't $64,000, Mr. Rubin was going to credit all of the fees that had gone towards terminating this trust. As you'll recall, Ms. McMahon, when she walked into his office, had a very broad range of things she wanted him to work on. And he spent a lot of time investigating whether there was other property in Canada. And so there were a lot of fees that had nothing to do with the Bermuda Trust. And so he was crediting back to her the fees that had been incurred on that basis. And so the $35,000, I think, that he was crediting in the claim goes to the fact that it wasn't the first time that it was brought up, was 2 years into the litigation. He was crediting it, and the trial judge went beyond that. And it really, unless this court concludes that oral modification is improper, this is largely an academic discussion about hybrid fees and bonus fees and whether you can charge a full hourly rate. And it is expressly contemplated by the agreement here, albeit only at a higher recovery. But that seems to indicate it's not a substantial or material modification. And it would be a really bad precedent for this court to say that an attorney's crediting hours back or cutting a client's fee in some manner renders the entire agreement invalid.
Well, it's obvious, at least from appellant's perspective, the estate's perspective, that the modification was only made to save the agreement from being held completely invalid. So to say that it only benefits the estate is a little bit disingenuous if the contrary is that the entire agreement is going to be stricken.
And that's their position. There's no evidence to that. I understand we only have Mr. Rubin's...
But you're the one saying that it only that it does benefit the estate.
Well, and it does. And what I'm saying is that attorneys do this sort of thing all the time, and there's evidence in the record of that. Mr. Lyles testified he's done it in contingency cases where a client comes back to you and says, you know, gosh, I thought I was going to have a lot more. Mr. Tanner testified he's done it in hourly cases where a client is, you know, wow, those are high legal fees. And for this court to say that an attorney making that sort of modification or giving that sort of credit thereby renders the entire agreement invalid, because it looks bad, would
Well,
be...
I think that their point is that it was invalid from the inception because it charged a full fee plus a contingency, whereas a true hybrid agreement has a reduced fee plus a contingency, and that no full fee plus contingency is valid. Can you address that for me?
Well, and what I'm saying is there is no case law that says you have to reduce the hourly rate.
But they all it seems like they all do have a reduced rate. And I can understand that that's kind of the purpose of a hybrid agreement, is that you agree to a contingency in exchange for a reduced rate.
All of the cases that they're citing on this point are fee shifting cases where the courts are determining whether to apply a multiplier to the lodestar amount. And there, when you apply a multiplier, that's because the attorney took on some risk because they risked non-payment. And so that's what the courts are really evaluating there, whether to apply the multiplier. In Lane versus Head is the key example. And I would note there that the attorney had only reduced his fee. It was from $150 to $100. So it was a partial reduction. But the court said it's that partial reduction that allows them to apply the multiplier. The court never says in those cases that you have to do that in order to comply with the requirements of the rules. And it couldn't do that because the rules don't say that. And it's also just good policy that we allow clients and attorneys to be able to enter into these sorts of agreements. Because on the attorney's side, when the attorney isn't going to be charging a retainer, which he testified in this case, he would have ordinarily required a $50,000 retainer. When he is going to be capping his fees, and I know that over time that was something that she was still going to be accountable for, but he's still fronting the money. Looking at this from the outset, he's going to be fronting the money if it involves litigation.
Do we know, is there a sense here in which we don't know the end of the story yet, because yes, he's gotten the Bahamas or the Bermuda money, but we don't know whether he's going to get the Bahamas money, and we don't know whether he's going to get the Canada money or the New York money. And so this agreement just continues, and he may in the end run up $2 million in fees that at $5,000 a month he'll never see, or something like that.
Absolutely. It's both a prospective and a retrospective way that this court is to look at the attorney's fee agreement. And, there were risks that he took.
He can't be out there still doing work on behalf of the dead person, can he?
Well, no. I understood Your Honor's question to be if she was still alive. I think the anticipation was he was going to keep
The
representing
agreement
her.
would still be in effect, and we wouldn't know the end of the story.
Right,
Yeah.
right, precisely.
So we probably wouldn't be here yet.
And then the client, on the flip side of that too, I think it's important to note, just as much as the client is a stranger to the attorney is a stranger to the client. And clients may want to have this option for a bonus fee, because if you're walking in and telling an attorney you don't know, that's never represented you before, that you're going to pay them $500 an hour for these very broad-ranging goals, you may want them to have some incentive to work towards efficiently and effectively toward the goal that you want. And so for all those reasons, there's nothing in Florida law that prohibits this court, or that prohibits the type of agreement. The trial court's determination that the end result here was not clearly excessive.
Well, how do you respond to the argument that the trial court read too much into the trustee's testimony, that he didn't say, I'm terminating the trust and giving her the $2.8 million because of anything the attorney has done or set up here?
I think that Mr. Hubbard's testimony on that, he talked about it both ways. I think in the end, the court needs to look at page 1244 of the record, when the question asked was, in the absence of such professional help, would you have felt comfortable distributing the assets of the trust to Ms. McMahon directly? And his answer was, probably not, because I was concerned she would be running out of money. And he also testified throughout about how he was happy that she had this professional help, and she felt comforted by what Mr. Rubin and his staff had been providing for her. And so it's the trial court's discretion, it's a fact finding, and there's competent substantial evidence to support it.
I guess their argument is that she was getting this $15,000 a month, and that by getting the $2.8 million, she really isn't getting anything more, because that $2.8 million can only generate so much a month. Maybe I'm reading too much in her argument, but really that's what it is. I mean, she really didn't, while in one sense it looks like she got $2.8 million, well, she had an income stream associated with that she now doesn't have. So why is this really a recovery of anything?
An income stream subject to a trust, subject to the trustee's discretion, subject to the trustee's fees, administrative costs that the trust is going to be continuing to pay. And this was her goal. This was what she wanted. She didn't just want $15,000 a month. She did not want to have to ask the trustee to give her more money when she needed it or wanted it. She wanted control of this money, and she did not have legal title to it. That's what a trust is. She has.
Well, then why isn't the recovery, whatever the value, the $15,000 a month stream has a value? And if you even want to discount that present value by the fact that it was contingent, she had to request it, that it could be denied, it has some number that some expert can associate to it. And you compare that to 2.8 million, you subtract the two. That's what he really recovered for her. He didn't recover 2.8 million. He recovered the difference of what she had versus what she got. Why isn't that? Maybe I'm making the argument that should have been made below. But, that's my fundamental problem here. He didn't recover $2.8 million for her.
Well, But the trustee has the authority. I mean, he had the authority. There wasn't even evidence in the record. I think Mr. Rubin talked about how it wasn't even clear that she would necessarily get the $15,000 a month. I mean, he had the discretion to say, I'm going to pay your rent and I'm going to give you money, you know, pay for your food, and that's all you're going to get. I mean, she had no control over it. And so that's what she wanted, was the control over the money. And the way that the agreement is drafted is to ensure that he gets her control of the money, and that once he did that, that's what an affirmative recovery is. And so they agreed that if it was any amount over that $15,000 a month, I don't know how you. I'm sorry, Your Honor.
So I guess the point is, I mean, the better argument, I'm playing devil's advocate here, but that was an argument for the estate to make at the trial level, to say, Judge, here's what she had. We'll discount the $15,000 a month because every third month he didn't pay her anything but her rent. And so when you look at this income stream over her life expectancy, it's $2.4 million. He got her 2.8, so he's entitled to a contingency associated with $400,000. And that was their argument to make below.
Right.
If they didn't make it,
I mean,
so everything I'm thinking of is you know, just like the argument you're going to think of as you walk out the door.
Right, right. I mean, the arguments that were made is that the fee agreement was invalid and that the contingency didn't occur. And as far as what the damages were, that's not before the court here today. And what the agreement said, I mean, it was meant to be broad to ensure that Mr. Rubin was working towards the goals that she wanted, and to ensure that it encompassed what the parties had contracted to. And so I think with that, unless this court has any further questions for me, we would ask that you affirm the judgment. Thank you.
With regards to the crediting back and giving the full fee, I urge this court to look at the Scannell versus Jones case, and it's a Louisiana case. But if you look at the facts, it's a full hourly rate charge, $150,000 retainer, and then a 33% contingency, and then the hourly rates were supposed to be credited back upon payment of the contingency. That court found that that was an invalid agreement against public policy because...
But that was public policy in Louisiana, though, right?
Correct. Under their bar rules, which are very similar to ours.
What's your best case outside of the fee shifting context, which I understand, I mean, Ms. Brewer's argument on that makes sense, that when you're in the fee shifting context, the question is whether there was a risk, and if you get the full hourly freight, there's no risk, and so you don't get a multiplier. That makes sense to me. So what's your best case outside of the multiplier context that you would point us to for the proposition that full hourly rate plus contingencies violates Florida's public policy?
There is no case because there is no court that has addressed an agreement between an attorney and a client dealing with this agreement. Every case that has been decided in Florida deals in that fee shifting context. The only case that we, again, the Scannell case is the closest we could find, and that's under Louisiana's law. And one last point with regards to attorneys cut fees all the time. That may be true, but they also issue a closing statement and it's in writing, so it's absolutely memorialized, and that never happened here. There was no closing statement and was never memorialized, so we're not asking this court to invalidate any time an agreement is modified, so we believe that's different, and for these reasons we ask this court to reverse. Thank you.
All right, thank you, counsel. Thank you both for your argument. We'll be at recess for 10 minutes while we reconstitute the panel.
All rise.